a judge should respect the lawyers and the litigants, shouldn't decide to respect the lawyers and the litigants until the judge gets the respect. I think just the very process of it, everyone deserves respect in the courtroom. The lawyers, the judge, the participants, everybody who walks through the courtroom door.
But what should a judge do if it's not there?
Certainly not allowed to go on, because I think if the judge allows it to go on, then the judge is just as guilty as the lawyer. I personally would probably ask the lawyer to refrain, and if afterwards, I would probably make a point to talk personally one-on-one with that lawyer, instead of embarrassing the lawyer in the courtroom in front of his or her client. Because after all, everyone together, the defense lawyers, the judges, we're there to promote the rule of law and the justice system in general. And to handle it publicly, I think gives a disservice to the system in general.
Alan?
I think there has to be civility in the courtroom. I really don't have very much tolerance for inappropriate behavior, certainly not based on any bias for gender or race. I think it goes back to, well, I think we do have a lot of talented lawyers in this county, and sometimes you can lose sight that we are a business, but first and foremost, you are in a profession. In this particular situation that you're talking about, I would hope as a judge that I don't have the personality to publicly admonish someone over that. I would rather call both counsel back into my chambers to ask them what's going on and to ask that particular remarks be halted and continued in an appropriate manner. I believe in respect and dignity for everyone in that courtroom.
Valerie?
I think it is very important, and it is a judge's role to enforce civility in the courtroom. A judge has to lead by example. I think if a judge sets the right tone by treating everybody with respect and dignity that they deserve, that most of the time the parties will follow the lead. However, there are circumstances where that may not occur and where the judge does have to take some action. I have had not many, I'm happy to say, in the 18 years that I've been practicing, but I have had a few circumstances where I had attorneys being discourteous and rude. What I did was I just called them up to have a sidebar. The attorneys talked to them about it privately, warned them that it wouldn't be tolerated in my courtroom, went back to the proceeding. If it does happen repeatedly, in this one case it did. It happened repeatedly, and I actually warned the attorney then, and if it continued, I would stop the hearing and we would reschedule this another day, which I really did not want to do, because then that's everyone involved, the police officer and all the parties would have to come back. But I gave a very stern warning to the attorney that I was close to doing that, and if it happened anymore, that I would halt the proceeding. That wouldn't be tolerated. Unfortunately, that worked, and the behavior ceased, and we were able to go on and have a civil hearing as we should have in the first place.
Chuck?
think
Please use the microphone.
I think what judges fail to realize is that respect needs to be earned. And this idea or theory of civility goes both ways. It goes between a judge and between an attorney as to their conduct. I had a judge that took me so off guard when from the bench he accused my client. Well, he didn't accuse my client, but he made this off-the-wall comment. I was representing a young father that had 2 children, one by 2 different women. And he said, "It sounds like your client has overactive sperm." And it took me so off guard that a jurist would say something like that. And you could hear a pin drop in that courtroom. Everyone was taken off guard by that. And I said, "What did you just say?" And he said, "Nothing." And he goes, "What do you want me to do with this order?" And I said, "Do whatever you want to do with the order." And I walked out. You talk about biting your tongue. Boy, did I bite my tongue on that one. In a situation like what you have discussed, this would not be a situation that you would admonish an attorney in the courtroom. You would go for a break. You would pull them aside, both of the attorneys, and say, "Hey, we're getting off the beaten trail with comments like this. You don't want to put something like that on a record and then embarrass everybody in front of their clients, but that's what I would do. Take a break or go off the record and pull them up to the bench and talk to both of them.
Tom? Can you grab the mic?
Sorry. I think it all depends on the circumstances.
Oh, I'm sorry. I was supposed to go on to a new question. But it's you first, so. This is related to the question we just had, it's just angled in a little bit different way. If attorneys are feuding in the courtroom, are disrespectful toward one another or toward other participants in the process, what should a judge do?
Well, that type of conduct is absolutely not to be tolerated. And there are different ways to handle it depending upon the severity of it. One would be a simple sidebar, where we would bring the attorneys to the bench outside of the hearing of the jury or others in the courtroom and tell them to stop it. Absolutely. And depending upon the severity, you could have a recess and go into chambers and do the same thing. Ultimately, a judge can sanction lawyers or hold them in contempt. And absolute civility is essential. Respect all the way around, from the courtroom to the litigants, to the lawyers, to the judge, both ways. And so the judge must be able to take control of his or her courtroom under the circumstances what is appropriate course of action.
Well, I think we have to recognize it is an adversarial process, and you're going to have zealous advocates in the courtroom. And a judge can set the tone through the decorum in the courtroom, through where attorneys are able to question witnesses in the courtroom, and has to demand that attorneys follow a certain manner of approaching cases and putting evidence in. If a judge does that and sets the tone, these types of issues are lessened. If you have that rare instance where they've gone well beyond where they should be, you can do it by way of sidebar. You can do it by way of going back into chambers and addressing both counsel. You know, in some respects, you have to have a timeout and redirect them at that point in time. Certainly, you can sanction them. You would hope that you'd never be in that position. But I think that you have to take a lesson from someone like Judge Gladden, who set a tone in his courtroom and in a very gentle but firm manner required attorneys to abide by that decorum, required them to ask questions from certain points in the courtroom, required them to ask for permission to approach witnesses, and certainly required them to make the arguments to the bench and not between each other.
Civility in the courtroom, we as our bar association have had numerous civility programs, CLEs over the years, because it seems lawyers have lost civility and don't know how to act properly. It's not a big problem, but it can be a problem. We have the epitome of civility in our bar association. It's Mr. Keller. He's here in the audience. Great lawyer, keeps his cool. I'm not sure how many family cases or divorces Mr. Keller's litigated, but that gentleman is an example for all of us. So the bottom line is a judge has to keep control of the courtroom and let lawyers lawyer, but when things get out of hand, put a stop to it.
Pete?
I think I'll actually get back to the question, if it was feuding or disrespectful attorneys between the two of them. If this is in front of a jury, a judge is going to have to be very careful in how he addresses it, because you don't want to give the impression to a jury that you're favoring one side over the other. So if it's in front of a jury, the first step that needs to be done is to halt the proceeding, and the judge needs to lead by example, but halt it in a respectful way. All right, I want the attorneys to approach, please come to sidebar. Give them an instruction outside of the ears of the jury so you do not impact the case. That is the utmost of importance, is to let the attorneys put their case in without a judge somehow impacting the jury's interpretation. If it's a situation where it's outside of the presence of a jury, and whether it's a family law matter, custody support, PFA, if the attorneys are really going at it that bad, you just simply stop